Welcome back to Channel World Seed, here in the studio and to our guests online. We've got a very important conversation today. We're going to be talking about dispute resolution, because every day across the global seed sector, contracts are agreed and trade takes place across borders underpinned by the ISF trade rules. And since the 1930s, these rules have provided a structured framework for resolving disputes arising from international sales contracts. Over time, that system has evolved to include mediation and conciliation, as well as dedicated provisions for more complex issues such as intellectual property in plant breeding. However, while these rules are widely used, they are often misunderstood until a dispute arises. And in 2024, ISF introduced a more harmonized approach through the creation of the ISF Chamber of Arbitration. Now, this was a means to strengthen consistency and professionalism at a global level, while also maintaining the role of established national systems in France, Italy, Germany, Argentina, the Netherlands, and Australia. Now, today's panel session is going to explore how disputes can be managed more efficiently, how companies can use the ISF system more strategically, and what lessons can be drawn from the long-standing experience of GAFTA. Now, I am joined by three fantastic panelists, all with very different perspectives on this. I've got in the middle here, we've got Helene Guillot, who is representing the ISF Arbitration Chamber. To her left, we have Fabrizio Ceccarelli, who is the chair of the Italian Chamber of Arbitration. And we have Jane Chisholm-Conte, OBE and Director General of GAFTA, which is really going to bring the experience from a large-scale arbitration system in global grain trade. But before we get into all of that, unpacking arbitration, mediation, conciliation, Fabrizio, I'm going to come to you first.
Yeah.
Can we unpack a little bit about the ISF trade rules in which we're unpacking this conversation today?
Yes, ISF has been very early in giving to the industry a nice set of rules and a general framework to facilitate the trade of the seeds and to reduce the problem of different legal system, the problem of different way of interpreting the business, establishing already 100 years ago, almost 100 years ago, a set of rules that was defining and ruling the trade of the seeds, and this is a good start point to avoid as much more as possible to have any kind of discussion or any kind of misunderstanding, but also providing the system of arbitration to try to solve any kind of issues that could arise up of the normal trade, not going on the court, which in particular at that time, we talk about 80, 90 years ago, could have been different legislations, different legal system, different habits and whatevers, but internally within a system created by ISF that was the arbitration chamber and the arbitration set of rules governing this process of arbitration. Mm-hmm. So that was already 8 years ago, because probably the seeds have been one of the goods that started to become internationally exported much more early than anybody else, and therefore a sector that became internationally involved much earlier than anybody else.
And Fabrizio, I'm going to come back to you shortly, and we're going to hear a little bit more about the system in Italy. Helen, I'm going to bring you in next. So 2024, ISF created the Arbitration Chamber. Can you tell us a little bit about why that shift was needed and what changes that's brought?
Yeah, thank you. So before 2024, and when Fabrizio mentioned since 1930 in theory, but it depends on countries, arbitration were organized at the national level. Mm-hmm. So each national seed association had a working arbitration chamber. When there was an arbitration to be done, then it was done at the national level. There are not so many disputes, and that's very fine in the seed sector. Mm-hmm. So some arbitration chamber even never knew about having a dispute to organize. Some chambers were having one dispute every 10 years, one every 20 years, it really depends. Some were more active. we could find disputes more actively in France, in Italy, in Germany, in the Netherlands. So basically it's more or less the 6 arbitration chambers that kept their competency to organize arbitration. But all the other national arbitration chambers did not really have enough cases per year to maintain a list of arbitrators, to have a secretariat able to handle an arbitration. So instead of running into the complexities of reorganizing everything at the national level, we thought it would be better if it is centralized at ISF. And since 2024 now, there is an ISF arbitration chamber that would know of an arbitration case if it happens in a country where there is no national arbitration chamber. So it's very recent. ISF Arbitration Chamber did not have any case yet because, again, there are not so many disputes around in the seed sector. Most of the disputes are solved amicably by companies between themselves before reaching the state of arbitration or going to court. So that's very good. But we are here and we are ready to function now. We have a good list of 35 arbitrators to know about any disputes around the trade rules that Fabrizio explained. And we also have 5 arbitrators to know about disputes related to intellectual property and the topic of essentially derived varieties. If we have any case related to this topic, we have 5 experts on IP, but again, this is quite rare that we would need an arbitration on this topic.
Okay. And where you've said there's very few disputes, I mean, Jane, bringing you in here, obviously coming from GAFTA's perspective, you've got one of the largest and most established arbitration systems in agriculture trade globally. Can you give us a bit of a sense of the scale of some of the cases that you deal with and maybe some of the lessons that we can learn from that experience?
Thank you, Claire, and thank you to ISF for inviting me here today. Yes, I mean, GAFTA deal with a very large number of disputes each year. The average is really between about 300 and 600 claims a year, but we have had it as high as 1,000 claims. The average claim is worth about $1 million, but we have had cases as high as $52 million, and we have a full-time team of 4 staff who manage our arbitration department, and just over 80 arbitrators spread worldwide who deal with all of the GAFTA cases.
And what are some of the patterns that you're seeing repeatedly across some of these disputes that you're mentioning?
That's a very good question. We do actually look at trends, and we publish arbitration statistics every year. So we look at what particular contracts tend to be involved in arbitral disputes, which regions are they coming from. Almost always disputes are generally linked to market volatility that has been triggered by some sort of geopolitical event.
And Helen, I'm going to come back to you very, very quickly. One of the things what you mentioned when we were having a briefing session before our panel is that often companies using ISF trade rules, they maybe don't fully understand them until something goes wrong. Where are the biggest confusion points happening, and why is this the case?
So indeed, like Fabrizio mentioned, the ISF trade rules have been here for almost a century now. And they have been included in the seed contracts since decades. And when everything is going well, people don't read the seed contracts. It's written somewhere, very small, ISF trade rule, ISF arbitration in small. Something very valuable is that seed contracts are quite short. It's often only 1 page back and forth. There is a tendency now, I heard, that contracts are getting longer and longer, 20 pages, that's getting complicated, but historically it's just a 1-pager, and ISF trade rules, ISF arbitration is written in small somewhere, and so they don't pay attention anymore to this, because they don't, also contracts are not renewed, the templates are not renewed, so it's been there. unless there is an issue, nobody really reads the contract, honestly. Yeah, so that's. So I don't know if you want to talk today about the corner that we have.
Oh yeah.
We have an info corner just at the entrance of the trade rooms over there. So it's great because then I can really discuss with traders. Some of them said, "Oh yes, indeed, there is somewhere mentioned in my contract ISF, but I don't know what it means behind."
Yeah.
So then we can discuss. But it's also learning for me because when we are at ISF Secretariat, we are not so close to the traders, and the practices are really evolving over years. So it's a good learning for us also to understand how the contracts evolve, how the lawyers are getting more and more involved in the discussions. Some of the traders here were telling me, well, I'm signing the contract and I would be dealing with disputes, but honestly, this is the legal department making the contract, so I don't know how this works. So it's also good also to have this kind of feedback to understand concretely how it works in seed companies.
Amazing. Fabrizio, I'm going to bring you back in because, of course, in Italy, you've retained the National Arbitration Chamber. What is some of the reasons behind keeping this in-house?
Yeah, thanks, Claire. The Italian Arbitration Chamber is also very old. Actually, it was founded in Italy before the Italian Sea Trade Association joined the ISF system, I would say. So it started as the Italian Sea Trade Association Arbitration Chamber, and then it became an arbitration chamber of ISF. After that, the ISF set of rules and arbitration rules were established. So basically, we kept during those about 100 years both the system of the two arbitration chamber existing at the same time, the domestic one, so the Italian Sea Trade Association Arbitration Chamber that was arbitrating mostly disputes arising among Italian members of the Sea Trade Association, which honestly were not that much, or hopefully was not that much in numbers during the year. And then, at the same time, the same arbitration chamber was also arbitrating basing on ISF rules for cases which were internationally involving companies, both member of ISF, of course. In that spirit, the arbitration chamber has been always kept alive, maintained. We have kept the arbitrators well exercised, because for one way or for one reason or for another, we had several cases per year, in particular because of the same reason why then ISF decided to make the central arbitration chamber in Nyon in Switzerland, because the rules say that the eventual arbitration should take place in the country of the seller, and at that time almost every country, so I'm talking about decades ago, almost all the countries had their own arbitration chamber ready to make her job in case it would be requested because of an arbitration case. Then the numbers started to be reduced because some of the arbitration chamber, they didn't have any more the experience, or they didn't have any more the energy to keep the arbitration chamber alive, and we remain less and less country with an arbitration chamber existing. And so when an arbitration was requested in a country where the arbitration chamber was not existing anymore, inevitably the secretariat of ISF was giving the arbitration to one of the existing chambers. So more and more arbitration came to the existing one, which are, as we said, Italy, France, Germany, and whatever, and that has helped to keep the Italian arbitration chamber active, alive, and well exercised in the role of being an arbitration chamber. But of course, we welcome the opportunity to have it centralized in Switzerland, in Nyon, and we think that there is no reason why both the systems can live together, that one of the Italian arbitration chamber and that one of the arbitration chamber in Nyon.
Jane, you were saying earlier that an average dispute could be $1 million up to, I think you said some cases around 50 million. What separates a dispute that is resolved efficiently from one that becomes long and becomes costly? What are the sort of differences?
I think that's actually very difficult to say. I mean, obviously the ideal scenario is that people don't come to arbitration at all in the first place, that they are able to resolve their disputes, they are able to protect the business relationship and to move on and carry on. And the reason that people come to arbitration are very different as well. So that's tends to sort of drive how long it actually takes.
Okay.
So some of the sort of common issues that come up, was there a contract, for example?
Okay.
So, one party will believe that there was a contract, the other one will say, no, we're just negotiating. Issues around buyers not paying, the quality or the conditions of goods, these are the kinds of things that come up. But of course, there are a whole range of other more complicating factors, particularly once you start to bring in supply chain issues, war, sanctions, these all impact. Having said that, from our statistics last year, the average length of time that our 125 rules, so that's the standard arbitration rules that we use, takes is approximately 7 months from start to finish. So it's not that long a period of time.
And you said, obviously, the important thing is maintaining those relationships.
Yes.
Does that mean, in general, it's the mediation phase that you're really focusing on bringing, and then it obviously then ends up in these more costly, longer stages? Is that the real focus?
Well, GAFTA, like other soft commodity trade associations, do offer mediation services. They tend not to be taken up very well at all. There are, I think, a number of reasons for that, partly because brokers are used very extensively in our trades, and brokers very often act as informal mediators because obviously they want to keep the contract alive if possible. And also I think that arbitration is a very cost-effective way of dealing with disputes, and if you're in the mindset that you haven't been able to resolve your dispute, you want to have a yes or no answer, then it's a logical step to go forward.
I might stay with you, Jane, because I know you've been involved in some training that took place on Sunday just ahead of the Congress. Can you share a little bit about some of the experiences and I guess the key lessons that you were sharing that day?
Well, it was a very interesting session, and again, very grateful to ISF for inviting us. And having the opportunity to speak to a number of ISF arbitrators, also hearing about ISF's own arbitration system and its plans for going forward. I mean, we overran. I mean, I think we went on for about 2.5 hours, and I think we could have talked all day, actually, because there was so many interesting things to actually look at. And of course, it's also very important that, there is no one right way to do arbitration. All arbitral bodies will do it differently. And I find it really interesting to come along and listen to how other arbitral bodies manage this service, because there's always something that you can learn.
Yes.
And Helene, obviously you both were taking part in that training on Sunday. I think you said earlier there's 35 arbiters that you were training up. What was their takeaway from the experience on Sunday?
Well, I think
I'm sure you've not been around to everybody to ask, but
yeah, some of them are sitting here, so they can also explain what they felt about the training on Sunday. But yes, it was the first time we were having this kind of meeting, because the ISF Arbitration Chamber was created only 2 years ago, and it's very important to train the arbitrators for this important role. Arbitrators, we can say a few words about them. That's quite different from the GAFTA, where you have professional arbitrators undertaking a proper legal training. At ISF, our arbitrators are mainly from the companies, so they are working in the companies, seed companies, or they are retired people also that keeps offering their service. So we have really different background, from CEO of seed companies, business managers, lawyers. We still have some lawyers, of course, from seed companies. We have retired experts from the seed sector. Really a great diversity that could allow, so in a case, and during an arbitration case, there are 3 arbitrators that would judge a case. Parties choose each one arbitrator, and the ISF Secretariat would nominate the third one. So with this diversity of background, we can make sure that there would be different eyes and expertise looking at the case. There would be like more the lawyer looking at the contract and how we should apply the ISF rules. There would be then the business sensitivities also around the practice of the seed sector. So we are pretty confident that this list is good, but now we need to train the arbitrators to make sure they understand their role, because it's very particular. Arbitrators are founding their judgment on what they think is fair and according to the practices of the seed sector. They are not here to apply any kind of rule. They are not bound to apply the French law or the English law, depending on where the arbitration takes place, or the Swiss law. It's really up to them of what they feel is fair and according to the seed practices. So we have to make sure that arbitrators are comfortable in their role and also aware of the code of ethics. Because we have a strict code of ethics for arbitrators to follow, that they should keep impartiality, they should keep, of course, all information confidential. It's not because they are nominated by one party, but they are representing the party that nominates them. After the nomination, they become absolutely impartial, and they need to follow what they feel is right. So we have to make sure that the arbitrators are trained, aware of the code of ethics, what can be done, what cannot be done, and GAFTA has so much experience about that it was very valuable for us to learn on how it's done and handled very professionally at GAFTA.
It's so interesting taking that industry expert approach and having that training as part of that. I've got more questions, but I'm looking at the clock and just wondering, are there any questions or maybe experiences from the room if anyone would like to ask a question? Because we could probably just keep speaking all day. Gentleman at the back. I don't know if is there potentially a microphone, or?
Yes, we have.
There is a microphone. If you could introduce yourself as well, that would be wonderful. Thank you.
Hi, my name is Xiang Xu. I come from Taiwan. We represent a Taiwanese company. It's called Non-UC. Well, we have a partnership, customer in Italy that have been dealing with us like almost 20 years. But recently we run into a situation that they have basically they owe us money they don't want to pay, and they're kind of dodging it for many, many times. We don't want to take it to the core, but I mean, with the arbitration, my question is, for C company, how can we utilize ISF arbitrations? How can we apply for help from you guys to, I'm not saying to forcing forcing them on so they can sit on the table and then start conversations before we hit the court. But I don't know how can you guys can help us as a seed company.
Well,
that's the things I'm kind of curious about.
Well, thank you so much for sharing. I was going to come to Helene, but maybe you want to comment on that first?
No, well,
as you want, Helene.
Okay, I can go for it. So thank you for your very practical questions that can happen to many companies. One customer, one part doesn't want to pay the invoice. Well, it's very simple, and we have really updated our website to make all the information there. You have a generic email address. It's arbitration@worldseed.world. We can talk after together, no problem. I can give you the email address. And you address your case. There is a list of documents that needs to be provided. You need to provide the contract. You need to provide all the elements that are relevant to the case. And then we will start to discuss and see how we can organize an arbitration. We will encourage you to go through mediation and conciliation first. This is a softer way to solve disputes, of course. And there is a specific process within ISF also for mediation and conciliation. And then if this did not succeed, then we would go to arbitration. We provide you with the list of arbitrators. You choose one, and we contact, so ISF would contact the other party to provide them with all the elements, the fact that you would like to start an arbitration. They would choose an arbitrator as well, and then it will be mainly online. So we try to keep everything online sharing of documents, and online hearing. If we need to do a meeting with arbitrators and the parties, we try to keep it online. so the cost would be really reduced. There is a fee to pay, it's 8,000 euros. The fee is to initiate the arbitration. This would cover the cost of arbitrators. Very openly, our arbitrators are paid 1,000 euros per case. It's not a lot, it's just to compensate. And on top of that, they may have travel expenses to cover. So we ask the initiating party to pay 8,000 euros. But after that, the arbitrators would choose how this 8,000 euros would be divided. Very often it's the losing party that would have to pay the fees, and the winning party is reimbursed if it's the one that paid the 8,000 euros. So it's a simple process. We can discuss further about it. And so the arbitration would take place in the seller's country. So I guess you are the seller in the case. And there is no arbitration chamber in your country, so that would be at ISF, would take place at ISF. ISF would organize it. If your counterpart was the seller, so Italian, in Italy there is an arbitration chamber, so this would be taken care by Fabrizio.
Well, Fabrizio, how fantastic to have that example.
Exactly.
And that is exactly the conversations they're wanting to have at the conference to explain what's available. So thank you for sharing, Helene. Fabrizio, I will come to you. You're nodding there. How would you handle this?
The case that was
Yes.
proposed by, well, if the case is just related to the not payment of invoice without claiming any other reasons, there is the expedite procedure, which is one simplified procedure present on the ISF rules to be used only in case of no payments. So if there are just no payment of the invoice without any claim of any other reasons why the invoice have not been paid, then the expedite procedure is a very fast solution, because it is a simplified procedure compared with that one of the full arbitration case, let's say. The number of the arbitrator is basically reduced from 3 to 1, so it is also cheaper than the first one, and gives the same kind of solution of the arbitration, which is an award where the arbitrator will say if that money is due or not, and will ask the party in default to pay that. So this is only in the case of not payment of an invoice, and the procedure is simple, is very fast, is not too expensive, very efficient in terms of cost and time, and very effective in terms of quality of the results normally.
If you could just have a quick follow-up just for our time, but thank you.
Well, once again, thank you so much. I just wanted to be quick. So, just out of curiosity, we don't know about this. We don't have a contract beforehand and stating that we put ISF arbitration inside. Would that still work? We only have like commercial invoice in between. In which angle the ISF arbitration can step in? I don't know how it works.
I might, if that's okay, just for the practicality of time, maybe to finish this conversation afterwards, if that's okay. But thank you so much for sharing. And I guess just a very quick whip around, if you can answer this in just the last little bit of time that we have. If, Jane, I'll come to you first. If you could change one behaviour across the industry when it comes to disputes, what would it be?
Read your contracts.
Read your contracts, as is being demonstrated. Yeah. Helene?
Yeah, well, I don't feel... Yeah, the clarity in contracts is very important, and we will follow up on the questions. Yeah, that's the key thing to check.
Read your contracts. Fabrizio, are you third here? Are you going to say the same, or?
Yeah, thank you. I will say the same, but I will make it a little bit further. Make a contract in written,
Yeah.
because very often we talk about verbal contract, things like that, and these. Very hard then when we enter in practice, in particular for arbitrators, which are not legal people, so we are not binded to legal principle and whatever. So we are more technical people. We are the big advantage of the arbitration is that you have people evaluating the case, which are business people involved in the same business of the case they are evaluating. So please make a contract. Not please. My suggestion is make a contract. make it in written, sign it, ask to your client or your supplier to sign it, and then you are quite a strong position and safe position for your business.
Well, I'm going to end it there. So what we've got there, read your contracts, write your contracts, and I think that's very important advice, and just so interesting to hear your different perspectives from GAFTA. Obviously, you're handling many more disputes every year, and how wonderful to have given that training to the arbiters on Sunday. And thank you, Fabrizio, for sharing some things from the Italian perspective. And Helene, you've obviously already shared a little bit today about some of the advice that you're giving out since this update came in 2024. So she is going to be around, so make sure you do speak to her throughout the conference. But I'm slightly over time. I do want to do a quick reminder for what's coming up in the next little while. So session here at the Channel World Seed at 2:30 till 3, we'll be looking at unleashing innovation, getting game-changing seeds into the hands of Africa's smallholders farmers. So make sure you're here for just before 2:30. But over in the plenary room, also at 2:30, but for an hour, it's Sowing the Future, What Now? The Biodiversity Framework for Global Plant Genetic Resources. So 2 fantastic sessions. But thank you to our audience here in the studio and online for your time, and thank you to our wonderful panelists.
Thank you.
Thank you, Claire. Thank you very much.
Thank you.
Thank you.